Hello everyone. Welcome to my channel Learn Law with Professor Rashmi. As you know, we have started with the series of lectures on the subject environmental law. In the last video lecture, we discussed about the Stockholm Conference. If you have not gone through that video, do check that video. Now, let us begin with today's topic. Today's topic is environmental protection under general laws in India. Why this topic is much important? This topic is important reason being, before any laws or legislations with respect to environmental protection were present in our country, we did have some protection or we sought environmental protection under these general laws in India. What are those laws? Let us see. We can divide these general laws in two broad categories. One is common law remedies, which basically talks about law of torts, and other is statutory remedies. It would include civil procedure code, criminal procedure code, remedies under Indian Penal Code, Factories Act, Municipalities Act, and other legislative or other legislations. Moving forward to common law remedies. Now, what do you understand by term common law? This particular word common law is derived from Latin word lex communis. It means that there is a body of judicial decisions which is based upon customary law. The judicial decisions which are given upon customary law, body of such judicial decisions formed common law. Before independence, as we were governed by British government, before independence we had this common law applicable in our country also. Post independence, now this common law continues to be in force in India under Article 372 of the Constitution. The environmental pollution remedies are available under Law of Torts in India. Let us see what are those remedies. What is Law of Torts? Tort is basically a civil wrong which is neither a breach of trust or a breach of contract. So it is a civil wrong which results in damage to a property or person or reputation, and the affected party can claim either damages or injunction or both. Now you all have already learned what is law of tort in earlier semester. We need not go into detail, but how are we going to apply this law of torts to our environmental problems, or how it was applied to our environmental problems? So basically, when anything is happening, any problem, any kind of pollution is happening to the environment, it is affecting society or public at large, it means that it is a civil wrong. This is how law of torts is applicable to environmental problems. In MC Mehta vs. Kamal Nath 2000 case, Supreme Court had said that environmental pollution leads to civil wrong and is a tort committed against the whole community. See, when there is a environmental pollution cause, air pollution, maybe water pollution or anything which is caused, it cannot be restricted to any single person. It is available or applicable against the whole community. So basically, this is a civil wrong and it is applicable, or it is committed, or it is considered to be committed against the whole community. Liability of polluter under law of tort is one of the major and oldest remedies which are used even before we had any other laws with respect to environmental protection specifically in existence. So this is having an oldest approval or one of the oldest legal remedies available. Now let us see what all is covered under law of torts, which all liabilities are covered. So nuisance, trespass, negligence and absolute liability. With respect to nuisance, trespass and negligence, you have already learned about it in law of torts. Now when I say term absolute liability, there may be a question what exactly it is meaning. So meaning is a stricter version of strict liability. You have already learned what is strict liability. So a stricter version of strict liability is absolute liability. Let us discuss this topic. What is a nuisance? Anything which is annoying or hurting or which is offensive is nuisance. We all know. So it can be any obnoxious smell, noise, fumes, air or water pollution which is happening because of the effluent discharge, or any kind of obstruction which is interfering with the right of any person to which he is entitled can be termed as nuisance with respect to environmental law. So basically you can say nuisance is an unlawful interference and person's right to enjoy nature or environment is affected, or there is an unlawful interference in such right. So this is what is nuisance. Now you can divide nuisance into private nuisance and public nuisance. You can see the explanation in this particular slide. Basically it means that there is an unreasonable interference between enjoyment of rights. If it is of a particular person or class of persons, it would be private nuisance. And if it is a general right which is affected because of this unreasonable interference, so general right of public is affected, it would be public nuisance. So primary difference between private and public nuisance would lie in the remedies sought. Public nuisance is treated both as a tort and crime. So there are different standards which are used to determine the nuisance in different areas. For example, a particular amount of noise won't be considered as a nuisance in industrial area, but same particular amount of noise could be considered nuisance if it is a residential area. A simple example to discuss. Moving forward to the case laws under the topic. Ram Singh versus Babulal, AIR 1982. This talks about this is a case of private nuisance basically. See, I have provided the two case laws, one is private and one is public. So you understand how they are interpreted as private nuisance and public nuisance. In this particular case of Ram Singh, the person had built a brick grinding machine and in front of it was a consulting chamber of a medical practitioner. So machine, obviously the brick grinding machine, it was producing a lot of dust and noise which was affecting the people or the medical practitioner who was having his cabin in front of that particular brick grinding machine. So the medical practitioner as well as his patient were facing physical inconvenience. Here Allahabad High Court said that this is a case of private nuisance because only a single person or class of person is affected. So it is causing a reasonable injury, discomfort or annoyance to a particular person, that is medical practitioner, or class of person, that is his patient. So this was a case of private nuisance. Now coming to what is public nuisance. Free legal aid sale versus Government of NCT of Delhi, AIR 2001. Now you will find that this particular case law would be repeated under different topics of environmental law. In environmental law, I have always been telling you there would be series of case laws which would be repeated under different topics. So what you can do is you can prepare a chart and mention a particular case and what all topics it is applicable to, right? So basically this free legal aid sale is talking about public nuisance. What is the case about? This here the petition is filed by Association of Public Activists in Public Interest. What is the petition about? Petition is about the noise pollution which is caused because of the display of fireworks and use of loudspeakers which happens during the festivals and during the marriages and other things, right? So it is causing physical and mental hazard to people or public at large. Here Delhi High Court observed that this effect of noise on health is hazardous and it has to be attended fully by the judiciary. It deserves attention from the judiciary. This is a wrongful contamination of environment and this noise pollution is regarded as a pollutant, it causes nuisance, affect health of a person also. That is the reason, and it cannot be restricted to person or class of person. It would be against whole community who is facing this contamination of noise. So this is a classic case of public nuisance. Now this case would also be covered under noise pollution rules. So remember that each and every case may have 2 or 3 areas where you can write down this case or you can mention the case. So remember that. Coming to next case law, Kuldeep Singh versus Subhash Chandra Jain, AIR 2000. Here there was a construction of baking oven going on and it was also going to have a 12-feet chimney, and this neighbor complained that there would be a nuisance caused which would be when the bakery would commence. So here Supreme Court has drawn a distinction between what is existing nuisance and what is future nuisance. So in case of future nuisance, mere possibility that something is going to happen is not going to provide plaintiff with any relief, but there should be a threat that there is an imminent danger, injury will be caused if this particular thing is allowed. There is an imminent danger. In such case, proof won't be required, but proper pleading should be done, and then there is, so proof of absolute certainty won't be required. See, what I am trying to say is something is going to happen. Merely something is going to happen is not going to provide any remedy. If something is going to happen, is dangerous, is of imminent danger, and there may not be absolute certainty that such thing would happen, so though that proof is not needed. But if it is proved by pleadings, or it is, if the court is convinced that yes, if such thing is allowed, there would be an imminent danger caused, then and then only injunction would be allowed. So here in this particular case, basically Supreme Court had distinguished between what is existing nuisance and what is further nuisance or anticipated nuisance, you can say. Okay, this was all about nuisance. Coming to the next tort, trespass. You know what is trespass? It is intentional or negligent direct interference with the proprietary rights. Okay, so it is an actionable per se tort. So I need not show any damages, that I have suffered any damages. As soon as there is something intentional or there is some negligent interference which is done with my personal or proprietary right, it would amount to trespass. Okay. So for example, when A is throwing garbage on B's land, or when A is discharging an effluent from factory on land belonging to B, whether intentionally or negligently, whether it is causing any damage or not, it is amounting to trespass. So what are the two basic requirements of trespass? One is interference, which can be either intentional or negligent, and other thing is the interference should be direct, it shouldn't be consequential. Moving forward to negligence. Now we have all learned negligence in Law of Tort. It is basically based on principle of fault. So what are the essentials of negligence? Essentials of negligence are, there was a duty to take care. A person was under a duty to take care, but due care was not taken by him, and when such due care has not been taken, it has resulted in some sort of harm. So in environmental law, you will find that when nuisance or trespass are not available, remedies under nuisance or trespass are not available, then negligence can be pleaded. But there has to be a direct link between the negligence and the harm caused, as well as it has to be proved that person who was guilty of negligence has not taken the due care. Let us see some case laws on the topic. Naresh Dutt Tyagi was a state of UP 1995. So what had happened in this case is that there was a godown in which chemical pesticides were stored, and this godown was in residential areas. The fumes from this godown, because of the chemical pesticides, emanated and leaked into the other property through the ventilators, because you know that fumes cannot be, or air cannot be kept at one place, it is going to travel from one place to another. So these fumes were emanated in the society or the residential place around this area through the ventilators, and resulted in death of 3 children and 1 infant in womb of a mother. So it was held to be a clear case of negligence. Next is Mukesh Textile Mills versus Subramaniam Sastry, AIR 1987. Now here again negligence is applied. Let us see how this appellant is having a sugar factory, and he is using that area for storing the molasses. What is molasses? Molasses is basically the byproduct which is obtained while manufacturing the sugar, and these molasses were stored in a respondent's in the appellant's land, which was close to the respondent land, and it was only separated by a water channel. So there is a appellant's land, then there is a water channel, and then there is the respondent's land. So here appellant is storing this byproduct of sugar, that is molasses, in tanks and their tanks are extremely filled with this molasses, and one day this tanks collapse. So when the tanks collapse, the whole molasses flow into the water channel, and through that water channel into land of the respondents. So what is happening here? The paddy field is, or damage is caused to the raised crop. The paddy fields are spoiled. So here court held that the appellant is liable because he had stored large quantity of molasses. Then he had a duty to take reasonable care, and because he could foresee that if such thing is happening, this would cause destruction to the paddy fields. So, and whenever such liability, because another thing is, this land was used as non-natural use, it was not a natural use of land. So court held that appellant is liable for the consequences of escape of the fluid from its tank, and this is a clear case of negligence. Now coming to the next concept of absolute liability. What is absolute liability? You must be aware of strict liability. What is strict liability, which was evolved in 1868 in case of Ryland versus Fletcher. So in this case, there was a strict liability principle laid down by the court, which said that any person who is bringing anything such thing on the land, or who is collecting such thing on the land, and if such thing is escaping, is causing the damage, then he is prima facie liable for the damage which is a natural consequence of such escape. This is a rule of strict liability. So anything, a person who brings anything on his land and collects and keeps there which is likely to do harm, if it is escaping, then he is liable to compensate the other for the damages. This is what strict liability says. You may also be knowing that strict liability is having certain sort of exceptions. So act of God, so person can take a defense that it was because of flood or earthquake which was not under my control, or it was because of act of some third party, or maybe plaintiff's own fault or consent it was, and I was only making natural use of land. Our a last exception would be of statutory authority. I was doing because I was advised to. So these all things, or these are the exceptions or defenses available under strict liability. So when a person is talking about strict liability, the other person can take one of the defenses. You will see that the strict liability principle was used for environmental law for a long time. So it was useful in environmental pollution where harm is caused by leakage of some hazardous substances. Only two things had needed to be proved. First is there must be non-natural use of land, and there should be escape of something which is likely to cause some harm, mischief if it is escaping. But you will see that this rule of strict liability was evolved somewhere in 19th century when there was development of science and technology has not taken place. So strict liability rule was evolved much earlier when development, science and technology has not developed in the society. Then with the economic developments and new challenges and situations, law cannot remain static and law has to evolve over a period of time. Law needs to be dynamic. So how this principle of absolute liability has evolved? Earlier, before this, we'll discuss this MC Mehta versus Union of India AIR 1987 oleum gas leak case. Before that, just immediately before Bhopal gas leak disaster had taken place, and that case was still pending in the court of law, and because strict liability rule could not be clearly applied because of the defenses which were taken, 6 exceptions to strict liability or defenses were considered and discussed about. So here court was of the opinion that when such things are happening and such hazardous things are releasing into the society, there is a huge damage or harm is caused, and now there is a need because of the economic developments or industrial developments which are happening. As society or new things are evolving, we need to evolve or come up with new principles which are going to apply to the existing problems. So in this particular case of oleum gas leak, Supreme Court evolved a new principle of absolute liability. So what does it say is that, see, why was this evolved, this new principle was evolved? With the reason being, the problems which are arising out of highly industrialized economy are to be dealt with new principles. We cannot keep on applying the age-old principles for our new problems. So here Supreme Court evolved with the concept of absolute liability. What does absolute liability simply means? Absolute liability simply means that it is strict liability but no defenses would be allowed. So strict liability minus defenses is my absolute liability. So what is the difference between strict liability and absolute liability? In case of strict liability, certain exceptions would be available, and in case of absolute liability, no exceptions. So whatever may be the reason for such damage or harm caused, and whatever may be the defenses a person needs to take, no, once it is proved that there was something stored which was not natural use of land and it has caused some harm, then absolute liability principle would be made liable. No defenses would be allowed which are allowed under strict liability principle. So always remember, absolute liability is strict liability minus the defenses available. So whatever it is, once you are storing or once you are using your particular land or premises for storing something which is hazardous, absolute liability would come in place. And it also said that in particular case, it was also said that what should be the measure of compensation? Measure of compensation should be correlated to the magnitude and capacity of the enterprise. So how much big my enterprise is, how much more capacity my enterprise has, as per that my compensation should also be more. So compensation should be made directly proportional to the magnitude and capacity of the enterprise. And what is this compensation is going to do? This compensation is going to provide a deterrent effect. So always remember, absolute liability principle was evolved in this particular case, Oleum Gaslick case. Then coming forward to Indian Council for Enviro-Legal Action versus Union of India 1996. In this case, Supreme Court reiterated the principle of absolute liability. So here in this particular case, it was said that the absolute liability principle which was evolved in Oleum Gaslick case, we have to apply this new principle, and we cannot say that we should apply strict liability principle, because now strict liability is not suitable for Indian conditions and therefore won't be applicable. We would be applying new principle, that is principle of absolute liability. In another case, Deepak Nitrite Limited versus State of Gujarat 2004, it was held that it was held that compensation should be directly proportional to the magnitude and capacity of enterprise, but it should also be correlated to the harm which is caused. So what if the harm caused is much more than the capacity or magnitude of that enterprise, then how much ever the harm is caused, that much compensation should be awarded. So in this particular case, the whole turnover of that particular enterprise, Deepak Nitrite, was awarded as compensation. So it did not only depend upon what is the magnitude or what is the capacity of that enterprise, it should also be dependent, or it should also be correlated or directly proportional to the harm caused by it. Now we have discussed all the four topics, that is nuisance, trespass, negligence and absolute liability. Now we will discuss what are the remedies which are available under torts law. So first is damages. What are damages? Basically a monetary compensation which is payable for commission of a tort. Then it can be of two types, substantial or exemplary. So what is substantial? To compensate for the injury or loss caused. So whatever exactly the loss is caused, that much compensation. And what is exemplary? Exemplary is much beyond substantial. So these damages are granted to have a deterrent effect, so that other person or enterprises or people won't commit the same thing again. So in case of environmental pollution, damages are generally claimed whenever there is tort of negligence or absolute liability. So these damages would be used in cases of negligence or absolute liability. Then coming to injunction. What is injunction? Injunction is stopping a person or prohibiting a person from doing something. It can either be temporary or permanent. So you have already seen temporary injunction can be given as a prima facie injunction. So here in this particular temporary injunction case, court will not go into the details who is right, who is wrong and what are evidences. Only three things would be considered. There is an existence of prima facie case, there is likelihood of loss or injury, or there is a irreparable loss or injury and balance of convenience is seen, and then temporary injunction is granted, and permanent injunction is granted after discussing the whole case, after reading, going through the case, after taking the evidences on record, and then deciding the case. While deciding the case, permanent injunction is given. Generally, injunction is used in cases of trespass or nuisance. So these are the remedies which are available under torts law. It can be a damages or injunction or both. Damages are generally given for cases of negligence and absolute liability cases, and injunction is granted for generally trespass and nuisance. So this was all about the general laws, basically the common law remedies or general law or remedies under law of torts. So environmental protection under law of torts is what we discussed today. In next lecture we are going to discuss environmental protection under law of crime. So it can be CRPC, IPC, and then we'll discuss nuisance under CPC also, and then we'll discuss some other statutory provisions also. Thank you for watching this video and stay tuned for upcoming video lectures. Thank you.